Welcome back to another Canadian Immigration Institute presentation. This is Immigration Nation. I'm your host, Mark Holthe, Canadian immigration lawyer, broadcasting live in this awesome little live stream that we have planned today. This is all about spousal sponsorship. I've invited my good friend Alicia Bachman-Bahari to come and be the subject matter expert for this video today. Those of you who have questions, we're going to try to confine them to basically to the nature of a spousal sponsorship application. I will be going live at 7 p.m. tonight for express entry. So this one is all about spousal sponsorship. So bring all the questions you have. And as always, it's sponsored by the Canadian Immigration Institute. All right, let's jump over here and welcome Alicia on. How are you, Alicia? It's good to have you with us.
I'm well, thanks, Mark. It's a beautiful day in Alberta.
Yes, it is. And we are dedicated, you guys, because it is 3 p.m. on Friday. Both Alicia and I are ready to check out for the week. It's been a really, really busy week. It was my first full week back from a little bit of a vacation. And it's crazy, just to see how fast the summer went. So I guess we're back into the groove of things now, aren't we, Alicia?
Absolutely. And I think hopefully things are going to be progressing with immigration sponsorships as well. So we'll turn our minds to what's going on with, I guess, processing too. So
yeah, exactly. We've got a lot of people I know that have been stuck in these massive backlogs because of the pandemic and the government's inability to really be, have the capacity to process paper when everybody was social distancing. So they're slowly starting to lift their way out of it, but there's a lot of people that have been suffering for a long time. Well, today is all about those who, you're in a relationship, you're ready to pull the plug and, I guess maybe pull the trigger on the sponsorship and move forward with bringing your spouse to Canada or sponsoring them to remain in Canada permanently with you as a spouse. There are, on the surface, it seems like it's something that's very, very easy, straightforward. Anybody can do it, but all I can say is not so fast, because there is a significant legal aspect to this that people, if they're not aware, can waste a lot of time going down a path only to see their application rejected. And then, not only are they suffering from the delays, but they also have to face the reality that now the second application, they have to make changes, and hopefully the ones that they've made are going to be good enough the second go round. So today specifically, Alicia, we are going to focus on sponsorship eligibility as well as the admissibility essentially of a spouse. And those are two critical components that are often overlooked by people when they dive right in. So Alicia, you've written a blog, and let's just shift over here to the actual website. So in here, you can see Alicia just released a blog, and if you want to access it, all you have to do is, I'll just close this and we'll go back to our main site here. So we'll go back to Healthy Immigration Law here. If you're looking to find it, and I'm going to shrink this page down a little bit so it shows everything for us. In the resource section, and there's a link in the description here, you can go here and access a lot of the blogs that we've done in the past. And so just click on blog, and then you'll see this latest one. Are you eligible to sponsor your spouse? Is your spouse admissible to Canada? And then the previous one, inside versus outside Canada spousal sponsorship, why the choice matters. So both of those were blog posts that Alicia has written. And so that's going to be driving what our discussion is today. And if you have questions and you can't remember exactly what Alicia told you, you can always go to our website, check out the blog post here. And then if you need further assistance, don't hesitate to speak to a lawyer. All right. So Alicia, where would you like to start with this issue? So I guess the first question I have is, why did you decide to write a blog on this particular topic or aspect of immigration?
yeah, and I guess it's because when I'm speaking with people, when we're doing consultations and people have questions about spousal sponsorships, this is often what I start by going through. I say, okay, well, understand that immigration has a two-stage process. And so if they're looking at the sponsorship as a whole, the first thing they're doing is they're looking at, is the person who's sponsoring going to be eligible to sponsor? And that is a fundamental question. And if you're not eligible to sponsor, you're done. The application is not going to get past that, but it's going to take months before immigration tells you that you're done if you haven't done your research ahead of time. And so that's the first thing I always talk to people about. And then the next thing is, well, great, if the sponsor is eligible, well, is the person that they're going to sponsor, otherwise known as the principal applicant, and their family members if they have dependents, are those people admissible? Is there a likelihood that they will be allowed in based on their personal circumstances? And so I thought it's really helpful to put this in writing, to have a few links so that people can easily see what are the things they should be concerned about looking into, so that we can, I guess, get a head start and people
Yeah.
can save a lot of time and aggravation.
Yeah. And I think that's the biggest point, because in many cases, when people are filing their own spousal sponsorship applications, they can eventually get it approved, but eventually is the key factor. And on the straightforward ones, things fall off the rails when you have failed to include what you should have included, or of incomplete information, and then it gets bounced, and then you lose months and months. But a lot of the things that we're talking about here are potential bars to actually being able to submit your application in the first place. And if you're not aware of them, they can catch you off guard. So
Yeah.
yeah, so that's really, so let's start with that sponsor. And so give me a typical scenario that you see, and we'll try to breathe some life into this. So what is the typical kind of a spousal sponsorship that you see? And I know we've got them all over the map, but maybe you can give us a little framework for people to think about.
Yeah. So a lot of the times people have had previous relationships, and they may have been in a common law relationship before,
Mhm.
or they might have been previously married, and this is a second relationship. And right away, there's a whole bunch of things that you've got to consider if you're looking at somebody who's been previously divorced or in a relationship before this sponsorship. Are there kids? What's happened with that prior relationship? Were they themselves sponsored? And is that an actual divorce if they were married? Is that divorce finalized? So all of those are huge things. And more, um, a lot of people have had prior relationships, and so it's
Mm,
an
yeah.
important factor to consider.
Yeah. Yeah. It's huge. I know in my experience, the spousal sponsorships that have been the most challenging and difficult are definitely the ones where you've got dependents from a prior relationship, an uncooperative spouse. That's when things really become a challenge. Okay. So let's flip over here, Alicia. I'm just going to flip over to your blog post. And so the first part, as we do some introductions here, is all about, are you eligible to sponsor your spouse? So
Mhm.
maybe you can talk about some of these important eligibility considerations.
Yeah. So the first thing is you've got to be a Canadian citizen or a Canadian permanent resident living in Canada. And there are some exceptions to whether you physically have to be living in Canada at the time that the sponsorship is submitted. But the general rule is that, yeah, you have to be a Canadian citizen or permanent resident, and usually you've got to be living in Canada. Sometimes, if you can prove that you're going to make your habitual residence Canada by the time that the person that you're sponsoring lands or becomes a permanent resident, then that might be okay. But you've got some more evidentiary burden. You've got to prove more things about how you're going to establish your life in Canada. So, generally, got to be living in Canada. For sure, you must be either a Canadian citizen or a Canadian permanent resident.
And it's interesting, Alicia, I just had a consult just today with someone who was a permanent resident. They had not been living in Canada for some time, but they were still within the range to maintain their permanent resident status. But they were in the UAE, and they met their husband, and they got married, and now she's very interested in sponsoring him. But the reality is, she asked, well, can I still sponsor if I'm living in the UAE with him? And then we got
Mhm.
into all of the discussion, and you guys out there, I can tell you, let's jump back here. One of the biggest things that you'll see is there will be helpful people out there that will be giving you advice that may borderline on something we call misrepresentation. So what she wanted me to basically explain to her was how she could go back to Canada for a short period of time, create a bank account, get a lease in place for an accommodation, and then leave Canada and go back to live with him while the application was being processed. And so that's what the advice initially that was being sought, because that's what people told her that she could do. And this whole issue of being present in Canada, if you're a Canadian citizen, then fine. You can
Yeah.
always provide evidence to support the fact that you can go back to, that you intend to return to Canada when the application is approved. But that is not the law for permanent residents.
Yeah. And so right away, being really careful, if you're a permanent resident of Canada, then you have to maintain your residency obligation under Section 28 of the Act, which means every 5-year period, you have to have at least 730 days of physical presence inside Canada. And so if you're in a situation like Mark, you were just describing, where you're overseas and you're at risk of losing your permanent residency and you want to sponsor a spouse, it can get really tricky and you can't misrepresent. You have to be honest about where you're living.
Yes,
Yeah.
exactly.
So the next thing, and this kind of leads into it, is that you can't be subject to a removal order. And there's a number of reasons that a Canadian citizen or a permanent resident could be subject to a removal order. It's much more likely that a permanent resident is subject to a removal order than a Canadian citizen. Once you're a citizen, it's much harder to have your citizenship revoked. But sometimes, if you're a permanent resident and you haven't met your residency obligation, those 730 days in every 5-year period, then maybe an immigration officer has written a Section 44 removal order against you. And if that's happened, you can't sponsor. You're not eligible to be able to submit that sponsorship.
Okay, so I'll jump in here now. A Section 44. Maybe you can just get people up to speed as to what you mean by that.
Sure. So it's a Section 44 report or an inadmissibility report. And so if a permanent resident has been outside of Canada too long and they try to come back to Canada, it's possible that the officer at the border is going to say, wait a minute, what's going on here? And issue them a report of a breach of their residency obligation. So they would not be eligible to come back in as a permanent resident until they settle what's going on with, did they lose their permanent residency? Have they been outside of Canada too long? Sometimes there are rights of appeal. But if you are subject to a removal order, then you can't file a spousal sponsorship.
All right. Let's keep cruising on here then.
Mm-hmm. So this doesn't happen often. Most clients that I've been talking to, at least recently, have been well over the age of 18 years, but the legal age of majority in Canada is 18, and so you can't submit a spousal sponsorship if you're under 18 years of age. The next thing is having legal capacity to marry, and that can get quite complicated, but it involves a few things. It involves complying with the laws of the country in which you're getting married. And sometimes people are getting married inside Canada, but oftentimes they were married outside of Canada. And it's important that the local laws were followed in terms of who has capacity to marry, who is able to be married. A lot of that has to do with, are you married to somebody else? Because most of the time you can't be married to somebody else in order to have a legal marriage that's recognized by Canada. You have to be over the age of 18, and you also have to be able to consent to that marriage. So having capacity involves a few different concepts.
Okay. Alicia, I remember when I first started practicing, I had a client who came over as a dependent in her family's refugee sponsorship application, through an UNHCR. And she was in, I think in Malawi, one of the refugee camps. And she received some bad advice, from someone there. I don't know who it was, but she was married at the age of, I think, 16 or 17. And then they told her, well, you don't disclose your husband because otherwise you'll be excluded from your father's refugee application as a dependent family member. And so that's what they did. And trust me, it went through a number of years of battle to try to get that sorted out for her to be able to bring her husband to Canada. So these issues on the surface seem pretty straightforward, but very, very quickly people can be caught unaware.
Yeah, and there's a section of the Immigration Refugee Protection Regulations called Section 117 sub 9 sub D, and so that's exactly what's going to exclude them in that circumstance. So not only is the daughter no longer a member of the family. She's not her dependent of the father anymore, but she's not able to sponsor her spouse because at the time that she would have been landed, if she got landed, then if she hasn't declared that she was married, if she was hiding the fact she was married, then she can't turn around and sponsor her spouse because Section 117 sub 9 sub D says that if you've hidden a spouse, you can't then turn around and sponsor them. They're never going to be a
Yeah.
member of your family.
Forever
And
barred.
yeah, there was some legislation that in some circumstances mitigates the effect of that legislation, but it still has a huge reach.
All right, let's continue down with some more of these
Yeah.
things.
So this is a big one, is if you have been in a relationship before, making sure that that relationship is completely finalized. And if you're if you are legally married, then there must be a final divorce. And sometimes it's tricky depending on the jurisdiction in which you've had that divorce adjudicated or it's gone through the courts. Some people don't realize that in many jurisdictions, there's a divorce judgment that doesn't become final until usually 30 days after it's been entered. And you can't go ahead and get married until that divorce is totally finalized. And so make sure that you understand what the divorce document is that has been issued to you and that it has taken final legal effect. The other tricky thing is if you were in a previous relationship that would have been considered common law. And so the definition of common law comes up often as well, but it's continuously cohabitating as a couple for at least 12 months. So in those circumstances, the people are not married, and it's a little bit fuzzier in terms of if that relationship dissolves, what's the day that it dissolved, and what sort of proof do they have that that common law relationship has been finalized. But making sure that the couple has proof of that before they get married in this new relationship.
Mhm.
So, along with that is if there has been a previous relationship. So, let's say the sponsor was themselves sponsored. So, let's say we have, I don't know, Larry, and Larry had been sponsored by Mia to come to Canada. So, Mia was the Canadian citizen. Larry, let's say, I don't know, was from South Africa. And he came to Canada and he's been living here, but that relationship dissolves and maybe he gets divorced from Mia. And then he finds somebody else and he doesn't even think about it. It's been, let's say, 4 years since he's been in Canada. He's now a permanent resident. He wants to sponsor his new spouse. And unfortunately, there is a bar, there's a sponsorship bar under the law that says if the person sponsoring has not been a Canadian citizen or a permanent resident, it doesn't have to be one or the other. You can combine citizenship and PR if the person applied for citizenship and met the citizenship eligibility requirements. But if that person has not been a citizen or PR for 5 years, they can't submit another spousal sponsorship for somebody else.
So I'm going to flip back here, Alicia. So what's the evil immigration is trying to prevent with this type of a rule? Like, why
Yeah.
was it created?
And this didn't always exist. It's a relatively new, I guess, piece of legislation or a change to the legislation, but largely immigration's trying to catch marriage fraud. They're trying to catch situations where somebody has a non-genuine relationship, a bad faith relationship. They come to Canada simply to get status, and then wait a minute, they turn around, they divorce that poor Canadian who sponsored them, and they get married to somebody else, maybe from their home country, and want to bring them. And so immigration is saying, wait a minute, this is not okay. And they're not going to force people to stay in terrible relationships. There was some incarnations of the law before that were a little bit draconian, but now they've said there's a 5-year sponsorship bar. So sure, you can get divorced from your Canadian sponsor if it's a bad relationship, but you're not allowed to turn around and sponsor somebody else unless you've been a permanent resident for 5 years.
Gotcha. Yes. All right. Okay, let's flip back.
Yeah. And so being really careful about noting the date that you
Yeah.
received your permanent residency and then making sure that you count forward for 5 years, because at the date that you submit the new spousal sponsorship, that's the date immigration is going to use to check. So whenever they receive your new spousal sponsorship, at that date, you've got to have been a PR for more than 5 years. The next thing is the undertakings. And so a lot of people don't really understand that when they're
Mhm.
sponsoring a spouse, they are making a binding legal commitment to the Canadian federal government. And it's an undertaking of support. So what they're saying is that as a Canadian citizen, I will take care of myself and my spouse and any dependent children that the spouse has. And I promise to do so for 3 years after my spouse actually lands in Canada, becomes a permanent resident. And sometimes they may have previous undertakings, maybe from that prior spouse, or maybe from sponsoring another family member, like a parent. And if you have other undertakings of support, it's stretching your financial ability to say that the person you're sponsoring or the group of people you're sponsoring will not go on social assistance. And so there can't be prior undertakings that have not yet finalized.
Gotcha.
Yeah. So along those lines, in terms of making sure, Canada wants to make sure that the sponsor is able to be financially supporting their family unit. The sponsor can't be receiving social assistance for reasons other than a disability. So if you have a disability and you want to sponsor somebody, that's okay. But if you're receiving social assistance for a different reason, that's not okay.
Right.
The next thing is, again, you can't be in bankruptcy. And again, that goes to financial self-sufficiency. And sometimes people say, well, wait a minute, for spousal sponsorships, I don't have to meet the low income cutoff guidelines. And that's true in theory, but there is also Section 39 of the Act that says that you can be inadmissible for failure to meet your financial obligations, or immigration, in other words, thinks there's a strong likelihood that if you're able to sponsor your spouse and maybe their kids, you're not going to be able to support everybody and you will go on social assistance. And so you don't technically have to meet the low income cutoff guideline, but you do have to show that you're not going to go on social assistance.
And I guess one thing just to confirm, if you've if you've received employment insurance because you've been laid off for your job, that is not considered to be social assistance for the, that would create a barrier to you being a sponsor. So with a lot of
Yeah.
people who've gone through, everything over the last year and a half with this pandemic, some have had to go on EI or receive those CERB benefits. And so those are not, I do not believe the CERB or the EI is something that would be considered social assistance for the purpose of a spousal.
No, yeah, not usually. There are some tricky rules because social assistance is a little bit different in each jurisdiction. So depending on which province in Canada that you live in, um, if you are receiving some sort of social benefits, it is important to talk to an immigration lawyer to make sure that it's not going to be a bar to you being able to sponsor. So yeah, some other things that can for sure derail your ability to sponsor somebody would be if you have failed to repay certain debts, and these are pretty specific. So I did put a link in to immigration's interpretation of the sections of the legislation that apply. So certain types of debts, failure to repay those could be a bar. You can't be detained, you can't be in jail, and there are certain sorts of criminal convictions, usually against family members or sexual offenses inside or outside of Canada, that would prevent you from sponsoring.
And
And then, of
one of the
course,
ones, one of the ones that we see quite frequently, or we don't like to see, but do happen, is domestic assault and those types
yeah,
of things. So that's
yeah,
exactly what that particular provision is targeting.
yeah. And so it's there to try to protect people who are being sponsored, to make sure that the sponsor, the Canadian, is not somebody who's likely to do them harm.
Perfect.
Yeah. So these are the sponsorship bars, right? These are the things that the legislation says if this happens, you're not getting past your first stage processing. That file is not going to progress any further. And it's really important to address these right up front. Make sure that there's no sponsorship bars, that you are eligible to sponsor. And if you are eligible to sponsor, great. The next thing is that the file is going to progress. And so processing has changed over the years. It used to be that files would be sent to different offices. It's interesting now because a lot of it is now becoming automated and online. And it's a little bit exciting because there's now going to be an online portal for people to be able to file spousal sponsorships. It used to be paper before, so this is a trial that immigration is just starting. So we'll see how this rolls out, but it's in the very beginning stages right now.
You bet.
Yeah.
All right. So, so Alicia, we have some people that are posting questions that are not exactly in line with where we're at within our presentation, but I thought just to kind of break it up, we might just address just a couple or one or two here. And this is one of the questions that we see a lot, just given the nature of how long it takes to sponsor a spouse. But but Omno here has indicated, we'll enlarge this just a little bit. It says, can I apply for a visitor visa for my spouse? And then the second part is, or is spousal visa the only way? Mm-hmm. So it's kind of a simple answer, but it'll give us an opportunity to talk about, to talk about some of the practical aspects of applying. So what are your thoughts with these?
And it's important to recognize that a spousal sponsorship is an application for permanent residence. This is not a temporary resident application. And a visitor visa or a temporary resident visa, TRV, is a temporary application to try to have somebody come on a short-term basis. And depending on which country the spouse is living in, sometimes it's reasonable to try to apply for a temporary resident visa in the meantime while that spousal sponsorship is being processed. It depends on whether that spouse can show a temporary intent. And so that's what the officer is going to look at. They're going to say, is your spouse likely to try to come to Canada and stay in Canada and never go back to their home country? So that's what they're looking at. And so it depends on a number of factors. What are their ties to their home country? Have they traveled internationally before? Do they have a job? Do they have enough money in their bank account? All these things to say, well, do they have a temporary intent? Can they come as a visitor in the meantime? Are they likely to go home? Will they comply with the laws in terms of coming properly when they're required to do so?
Yeah, and this is a good point. So practically speaking, you guys, I can tell you, and those who have been involved in this, if you're sponsoring a spouse from a visa required country, the fact that you have a spousal sponsorship in the queue, if you filed it, can be almost like a sledgehammer to anyone who's trying to apply to bring them also to visit. And immigration, this has been one of the points that, lots of people have been expressing a lot of disdain and frustration with. Over the course of especially through the pandemic, where processing times on the spousals have been so long, individuals say, okay, well, can my spouse at least come and visit me here in Canada? And often when they apply for visitor visas, they're refused because for a lack of immigration and, of temporary intent. And it's, even though within our legislation, we know that there is the ability to have dual intent, intention to come and abide by the temporary conditions of your stay, while at the same time intending to one day become a permanent resident, often officers will be very harsh and very cruel. And often, Alicia, I'll just give a little practical tip for me. I know when I have individuals that are in different countries and they know that they require a visa to come, often I'll tell them to consider applying for the visitor visa before they apply for the spousal. Now, with that being said, they still need to fully disclose who they're coming to see, that if they're married or if they're in a relationship or whatever, they're not just going to say they're coming to see friends. They want to be honest and upfront. But then when it comes to the application, if immigration refuses it, I actually use that in the context of the spousal. And I say, look, immigration, the department, I say, look, IRCC, they haven't spent a lot of time together because you refused the visa for the spouse to come visit her, the sponsor in Canada. And so that's just something to take into consideration. So Omno, the reality is no, you can do both, but it's more a question of whether or not you can satisfy those things that Alicia talked about in terms of demonstrating temporary intent in the context of the reality if you do come to Canada, most people don't want to be separated from their spouses. I know for myself, if I was, I look at what a lot of these people are going through when they're sponsoring a spouse. It's really painful to watch. And, I've got a ton of compassion for them because I wouldn't want to be away from my wife for a week, let alone a
Yeah.
year and a half, 2, 3. And some of the, cases that were brought forward to the Standing Committee on Immigration back in November, when they were looking at the ramifications of the pandemic on immigration, some people were looking at 4 or 5 years because they'd already been waiting for 3 years, just about ready to finalize. And then the pandemic hit and it tacked on more time. So these are realities for sure.
Yeah.
Let's see. I'm going to just pull up one more here from Siva. It says, can a sponsor travel out of Canada while the application is in progress or process? It's an outland application, so an FC1. It's in the stage where the sponsorship is approved and the primary applicant is in process. So what we don't have here is whether Siva or the sponsor is a permanent resident or a citizen of Canada. But even then, maybe let's address both of those, Alicia. What are your thoughts on
Sure.
that?
Yeah, well, the answer is yes. I mean, the Canadian sponsor can travel, well, depending on the travel restrictions and which
Yeah.
country you might be going to. So there's always that to deal with right now in the pandemic. But assuming that the sponsor has been approved, they're a Canadian citizen, they can travel. They can go outside of Canada, they can come back inside of Canada. It's not going to negatively affect their application for the sponsorship. If that person is a permanent resident of Canada, and let's say they get stuck outside of Canada and they're close to not being able to meet their residency obligation, that could be a huge problem. So whether that person's a Canadian citizen or a permanent resident does make a difference. But generally, Canadian permanent residents are able to travel. It's just a matter of how long are they going to be outside of Canada? Will they be able to get back inside of Canada?
Yeah.
Are there travel restrictions for whichever country they might be going to that would prevent them? Do flights still run? So those are considerations.
Yeah. And the main takeaway from that, you guys, is basically if you're a permanent resident, yes, you can travel. Like there's no restriction on traveling to visit or to spend, a little bit of time with your spouse abroad because the application is taking a long time. But the moment you relocate back to the foreign country, that's when you run into a lot of problems with eligibility because even though your sponsorship has been approved, immigration can still backtrack, right? They can still say, hey, you're no longer in Canada, like Alicia said. And in the world of pandemic, you have no clue what's going to happen. And immigration laws are only one thing. The travel restrictions are really the one of the main concerns right now that people are experiencing.
And the other thing I'll add to that too is if you do travel, you have an obligation to tell immigration if your address has changed.
Mm-hmm.
And so there's always a fine point about, if you're going for a week, well, you're not going to tell immigration what your hotel is.
Yeah.
But if you're going for a significant period of time, a number of weeks, if you're now living in a different country, then you have a positive obligation to update immigration for your significant contact information, your address, your phone number, and where you are. And as soon as you do that, then they might have questions about where your habitual place of residence is.
Yes. All right, let's jump back. We'll hold off. There's some other good questions and I can see them. And I appreciate you guys focusing your questions today on the topic, which is all about spousal sponsorships. So those of you who've posted comments, we will get to those in just a second. We're going to continue forward here with Alicia, and we're going to talk about some of the important considerations for the principal applicants or the person being sponsored and their children that might be included within the application, whether or not they're admissible to Canada. So why don't we touch on this, Alicia?
Yeah. So in this scenario, the sponsor's eligible. They've gone through first stage processing. It used to be CPC Sydney for everything. We'll see what happens with the online processing. But generally now the file is going to be sent to the overseas office wherever the principal applicant is living and their children probably or possibly. And then this is normally going to take a much longer time. So this is where things usually slow down. Immigration's got to see, well, is that family admissible to Canada? And is it a genuine relationship? So those are two big, huge questions. When they look at admissibility, they're looking at, can that person who's being sponsored establish their identity? Do they have a valid passport? Do they have birth certificates? is the name on the birth certificate and the school records and the passport, is it the same? Because sometimes it's not, and that can cause a whole bunch of trouble. So establishing identity, sometimes people need to renew their passport, so that's something to consider ahead of time. The other thing is there inadmissibility for criminality? And sometimes if you're sponsoring somebody and it's a brand new relationship, maybe the person that you're sponsoring doesn't really want to admit that when they were 18, they had a DUI and they got pulled over, and maybe they forget about it. It's been a long time, and they thought that they were rehabilitated. But all those things really, really matter and absolutely must be discussed with an immigration lawyer if you've ever been detained. So criminal charges of any sort, detentions of any sort, or convictions of any sort, even if that conviction was later appealed or pardoned, or you've done an application of some sort to try to expunge it, make sure that you talk to a lawyer about it, because it's essential that there's no inadmissibility for criminality. And sometimes it's possible to do a rehabilitation application depending on how much time has passed and the nature of the offense and how severe it was. Sometimes there might have to be a temporary resident permit application, which is not the same thing as a TRV. It's a TRP, also used to be called a minister's permit, but it's special permission to be able to come even if you are inadmissible. But criminality, it's a huge, nasty impediment to being able to be sponsored, but absolutely must be discussed and disclosed.
And, Alicia, as over the years, I can't tell you how many times the dreaded DUI has been the culprit. And often we see that, especially with the spousal sponsorships, which we do between Americans and Canadians, where it's their second marriage, their second relationship. And they might be 40, 50 years old, 60 years old, and they can't remember that DUI they had back when they were 19. But even that, it's probably one of the least serious offenses that still would be considered an inadmissibility to Canada. Now, obviously, Canada treats it a lot different than the US does with these offenses. And that's why sometimes Americans just feel that it was just a misdemeanor to some extent and not a felony offense. Whereas in Canada, we treat it as indictable or a felony level. And the consequences are pretty severe, even the punishment provisions, and that's been ratcheted up over the last few years as well.
Yeah, there were significant changes in the law in 2018, and it becomes very complex in terms of assessing criminal inadmissibility, especially for DUIs. So that's an area that requires quite a bit of review and research before you can decide whether you're even eligible to or admissible on a sponsorship.
Yeah. So this needs to be addressed right at the front before you start diving into anything else.
Absolutely. And it's really important because you don't want immigration to find this out when they're doing their background checks. You don't want them to realize that there's criminality and you've never brought it up before, because it's not going to go well. But if you know that you have an old criminal charge, let's say it was over 10 years ago and nobody was harmed, you've completed your sentence. That's another big thing about what was the latest date that you've actually completed your sentence. All of that needs to come out. You need to get all those details. You need to go get the courthouse searches ahead of time. You need to get your FBI reports. Sometimes you need to get local state police reports as well, the notes from the probation officer that you completed the offense. All those things have to be gathered ahead of time. So sometimes criminality is not end of story, but you definitely need to address it.
Yeah.
So same thing on the who's being sponsored on the principal applicant side. They have to have capacity to marry, and we talked about that a little bit before, but again, over 18, the marriage is legal in the place that it is performed, and it's recognized by Canada as being legal. And the next thing is a big one, and this is not necessarily it's not like a bar, but it is something that you have to prove. So you have to establish the relationship, either the legal marriage or the common law relationship. And if it is a legal marriage, then having a proper marriage certificate. And depending on the country that you're married, sometimes this is a little bit confusing because there might be a religious marriage and there might be a civil marriage. And making sure that you have that registered marriage certificate, what is legal and not just the religious document, is very important. Um, Also, and this is one of the things that becomes very subjective and why you might in fact want to use a lawyer, is establishing that additional documentary proof of your relationship. Because it's not always just what is on the checklist. Sometimes it's really important to go beyond that to establish, it's called the bona fides, or the genuine nature of your marriage. And if it's a common law relationship, even more so, there's more of an evidentiary burden. You've got to prove a little bit more because you don't have that binding legal document.
All right, that's a perfect segue into our next question that comes from Yaroslavna. She says, "Can you please give an explanation of the difference between conjugal partner and common law partner?"
Mhm. And this is an interesting one. So if you're looking, and I do have another blog post on this, but there's a difference between inside Canada applications, which are also called spouse or common law partner in Canada applications, or a family class application, which is an outside Canada application. But it becomes a bit tricky to think about because you don't physically have to be outside of Canada. It's just what they call it, but it's a family class application. Only in a family class application, an outside Canada application, could you have a conjugal partner. If you're looking at a spouse inside Canada application, there's no such thing as conjugal partner. It's not a category that you can sponsor. So if we're looking at the outside Canada sponsorship, you could possibly sponsor a conjugal partner. Conjugal is different than common law. Conjugal means that you have been together sexually, but you can't necessarily establish 12 months of continuous cohabitation. Or usually there's a legal impediment or circumstances in the world that prevent you from getting married, like a war, or maybe your country, maybe it's a relationship that's not recognized in your country of nationality and you're not actually able to be married. So conjugal partner is a very tricky category of application that I would not enter, and I wouldn't recommend filing a conjugal partner application on an outside Canada class unless you really know what you're doing and you've talked to a lawyer about that.
Yeah, and I think we see this in the context of some countries that have specific rules that bar certain types of relationship as a result of religious or customary practices in those countries. And so, if because of that you're physically prevented from being with them in that way, or there's like I said, there's conflicting religious backgrounds. Sometimes those can also prevent people from proceeding forward with relationships, and the only way to move forward is through the conjugal route. It's not easy, like Alicia said. If the facts are lined up and you can demonstrate it and prove it, and remember, it's not just a thing of convenience. So, well, we don't want to get married. There's nothing preventing us from living together, really. But I just, I'm happy with my job here, and the applicant is they've got their employment there, and it's just an inconvenience. That will never cut it.
No, and it's different than some sort of fiance class. This is not a fiance kind of situation. That has not been the law in Canada. So a conjugal partner is usually reserved for very specific situations. I did have one that I was helping pro bono on where she was living outside of a refugee camp, and the Canadian sponsor could only go, for a couple months a year, saved up all his money to go over to fly to be with her. And that one went through, but it was a lot of effort and a lot of documentary proof and letters from supporting family members and proving a very strong relationship over a very long period of time, but they were physically prevented from getting married.
Exactly. That's the key. Typically circumstances outside of your control. Now,
Mhm.
just a little follow up with Siva here. She just clarified that yes, indeed, the sponsor's a PR, and as well, the trip itself would be only for a short period of time. So, ultimately, I'm going to ring the bell right here. Oh, that's a little bit quiet. Let's turn that up a little bit. So the bell means these questions, we never ever give any advice to people specifically on what they should do or what they shouldn't do here in our Immigration Nation live streams. We always encourage people to go back and to book a consult. And I think if I just flip the screen back here, flip it back to me. When we are, you can always go back to, and there's a link in the description below. But if you go back to our website, and I'm actually going to shrink this down a little bit more so it shows up, you'll see here that there's a link for speaking to a lawyer. And it's as simple as clicking on that link and scrolling down, and you can find myself and Alicia and Susan. And it's really quite easy to book a consultation with us to get the specific advice that you need when, when you're trying to determine, should I travel or am I eligible, or those kinds of things. So just keep that in mind. And so ultimately we would say, probably if I flip back here to Siva, there's no law preventing you from traveling abroad when you're a permanent resident. But I think you've hit the nail on the head here with making that stay short and recognizing that there are risks if you leave. So be aware of those. All right. And then I have one last question before we jump back in. And it says right here, so this is PRs. That's awesome. Maybe it's permanent resident spousal. I don't know, short for it. Although I like that motorbike there. How long should we be a PR staying in Canada to sponsor a spouse? And the spouse is staying outside Canada. So this really is our classic express entry. And I don't know if this is the case with this individual, but when you have an express entry applicant who realizes that they're not going to get an ITA unless they list their spouse as non-accompanying and then sponsor them after. And this happens a lot. So then you come, you land, and then the question is, well, how soon can I turn around and sponsor that spouse? We know in the application guide that it asks for a couple documents. One of them is a notice of assessment showing that you're paying Canadian taxes, and a letter of employment from an employer showing you're employed. So what are your thoughts on that, Alicia? And I want everybody to understand that there is no fine line. There is no, no right answer. It literally depends upon the individual and the situation that they're in. But what are your thoughts on that, Alicia, in terms of turning around quick to, to sponsor? How fast can you do it?
Yeah, and you're right, Mark. It's very different if you're an express entry applicant. So if you are an economic applicant, there's no bar to you turning around and putting in a sponsorship for your spouse the next day. However, if you were yourself sponsored, then remember that 5-year bar. So if you're looking at that express entry or economic class, you've got to think about, well, I have to get past the checklist. And so this is one thing that is a little bit more tactical. But what happens is there's the immigration sponsorship checklist. And depending on whether you're sponsoring your spouse or common law partner, you've got to prove all these things. And in practice, what's happened is immigration officers tend to go through this checklist, and if there's any box that is not properly checked, or if they start rifling through the application and they don't see one of the documents that you're supposed to have, that application is getting returned to you faster than you can say boo. So if you don't have proof of employment, or if you don't have some alternate way to show financial self-sufficiency, it's possible that an officer looking through that really quickly might return it to you unless you're really careful
Mm-hmm.
in showing, here's exactly how I meet financial self-sufficiency. And maybe you don't have a notice of assessment, but they also say you can get a letter from your employer. It should be dated. It should have the letterhead of your employer. It should talk about what your position and your full name and the dates that you've been employed there, to show that you have some gainful employment. And then also you can supplement that with your bank account balance and show, I've got a history of earning income in
Yeah.
Canada. So those are alternate ways that you can prove financial self-sufficiency. So legally, you could turn around and submit that spousal sponsorship the next day after you got PR, but practically, you've got to prove enough evidence to get past that document checklist.
Yeah. The gatekeeper. Absolutely. Okay, let's wrap up the last few little things with respect to the applicant.
Absolutely. So when the person that you're sponsoring has children from a previous relationship, things also get pretty sticky. So making sure that if the person that you're sponsoring was previously married, that they're divorced, or that that common law relationship has dissolved finally, and if they have children, then it becomes interesting in terms of making sure that they are able to travel, that they have the permission of the local court to take the children out of the jurisdiction, and they've got consent from the the other parent of that person to allow the children to come to Canada or be sponsored for permanent residency. And it can get very difficult if the other spouse, the ex-spouse, does not want the children to come, if they don't want to have the children medically examined. That can be a practical impediment to ever having that file move forward. So it's a thing to consider if there are children from previous relationships. If you have older children from previous relationships who may no longer be kind of part of the family unit, they may have to get a police certificate if they're over the age of 18. So there's an interesting time between 18 and 22 where they may still be dependent children, in which case they'd have to get police certificates from any country they'd lived in since they turned 18 for 6 months or more.
And it's interesting, Alicia. I remember it's probably been 10 years now, but I had a couple in, the applicant was American and she was in Canada, and we were going through that process. She had fallen out of status and came to see us probably a year and a half after the fact. So she needed to benefit from the public policy. But she had some children who, at the time in which they applied and submitted the application, they were 16, 17 years old. And then by the time 4 years later, the one was 21, I think, and managed to get themselves a DUI. And and so at that time, that child, they were nearing the end 4-year road to get this application approved, and they refused the application. And I shouldn't say that because the child was actually 22, but because they were included and locked in. Now I remember what it was, because they were locked in. And then after they turned 22, I tried to get the officer to, to just allow it to go forward, given the time that had passed. But nope, they just refused it. And the moment they refused it, that dependent was no longer dependent, because at that stage they were 22. And then we refiled the application. But that's how harsh these rules can be. And they had no clue that this could have possibly been an issue, because that child hadn't really been a part of the applicant's life for over 4 years, and these things can come back to bite you. Mm-hmm.
Absolutely. Yeah, so it's really important to look at the whole circumstance of the entire family unit if there's been a previous relationship on either side, especially if the sponsor has a previous relationship and children from a previous relationship. The big thing here is misrepresentation. So a lot of spousal sponsorships will be refused for lack of genuineness. But also if there's been misrepresentation in the past on the part of that sponsor. So if this person who you're sponsoring has filed a study permit application, been refused, has put their name in the express entry pool but never gotten an invitation to apply, has applied 7 times for a visitor visa, and now they're being sponsored, and there's anything on those prior applications to Canada that they fail to be forthcoming about, or let's say they hide some of those prior applications, it's a big possibility that immigration is going to say there was misrepresentation, or it's not a non-genuine relationship, it's a bad faith relationship. And misrepresentation is something that immigration is going after with increasing frequency. At least that seems to be kind of the pattern right now. And it could be something as simple as, and I'll probably write a blog post about this as well, but it could be something as simple as failing to disclose a visitor visa refusal to a different country on your application to Canada. And that can be misrepresentation that makes the principal applicant inadmissible to Canada for 5 years.
Yuck.
So yeah, misrep is huge. So always, 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 honesty is the best policy. if there's something that you've forgotten in your application, it's important to fix it right away. But also, as the sponsor, talking to the person that you're going to be sponsoring, understand what sort of previous applications they may have made to Canada and be open and discuss what's been going on with their history. If that person that you're sponsoring has themselves been tried to be sponsored to Canada before, if they were married to a different Canadian and then that was refused, that's always a red flag. So a whole bunch of issues that would have to be discussed in that circumstance. Generally, Canada recognizes that if you're sponsoring a spouse, they want to make sure that spouses, even if they have medical conditions, should be able to be sponsored. So usually there's no medical inadmissibility on sponsorships, spousal sponsorships, but there is medical inadmissibility in a circumstance where that spouse would be a danger to the public for health or safety reasons. So there's narrow grounds there. And then there are other grounds of inadmissibility, and those can be quite varied depending on the circumstances of the individuals involved.
And that's a pretty good way to say there's a whole host of things that we have not considered or talked about in this live stream. But like we said before, if you have questions, if you are, basically you're uncertain of what you should do, it's always right here. You just have to flip over to our website and you can book a consult with any of the lawyers here within our firm, and we'd be happy to assist you. Now we have a couple, Alicia, just a couple last questions. One person seems like they're pretty anxious. So I will pull up their question. Okay, because they're begging me, they say here. I'm begging you. So please answer my question. I beg you. Are the sponsored people with COPERS allowed to travel to Canada as of now, fully vaccinated? And I'll maybe take the initial stab at this. So as of now, if you have a valid confirmation of permanent residence and if required, a permanent resident visa imprinted in your passport and they're valid, you can travel when you're fully vaccinated. Yes, the answer is yes, provided there isn't a ban on your country from coming to Canada or some other restriction due to the travel restrictions that Canada has with some countries. So I'm not sure if that's the case for you, Shrey, here. But the ability, you can always go to the Government of Canada website and you can see very clearly who's allowed to travel and who isn't. And at this stage, valid COPER holders are allowed to travel unless there's some other restriction that's based on a country by country basis. So that's probably the best way to describe it.
And September 7th was the date. So just this week, that's changed. And so there used to be a whole host of things we had to figure out in terms of what was the travel restriction and then what was the exemption to the travel restriction, and did the person fit within that category? And that's still the case if you're not vaccinated. But if you are fully vaccinated, then generally, yes, you are able to come. However, as Mark was saying, there's still some of those flight issues, right? Certain countries are not being allowed to have flights enter Canada.
Yeah, and I'll also point out that fully vaccinated, it has to be fully vaccinated with the acceptable vaccines. So Canada doesn't accept all vaccines that were ever created to battle the coronavirus. There are a set list of vaccines: Moderna, Pfizer, there's Johnson & Johnson. I can't remember what the other... AstraZeneca. So those ones, and they're all listed once again on the government website. So there you go, Shrey. I'm going to give us an applause for answering Shrey's question. All right. That is great. Okay. So those of you, there's some other people that have asked questions that are not related to spousal sponsorship. Remember, at 7 o'clock tonight, Mountain Time, that's in 3 hours, I will be going live again with a special edition of my old Express Entry live Q&A that I used to do in the early days. And so I'm kind of resurrecting that one, and the topic is going to be all revolved around Express Entry. So make sure that you join me at 7. Alicia has family stuff to do. She's going to spend some time with her family, and I'm going to jump on board and go solo for that one. But there's some other questions here. Maybe I'll get to one last question and then we'll wrap it up here with Yasmin. And so Yasmin says, should we submit divorce certificate with my ex-wife for an open work permit with my new wife? So I'm not quite sure, Yasmin, what the context is. So you're applying for an open work permit, a spousal, I'm assuming, for your new wife. And you're wondering if you need to prove that prior divorce. Well, typically when you have a marriage certificate, Alicia, I'm trying to remember what the document checklist says. There's no harm in including the divorce certificate to confirm that the marriage that you have now with your new wife is legal and authorized. But I can't remember if a divorce certificate is specifically required in that context.
Yeah, on a spousal it is. So if either party has been previously married, then the spousal checklist does say to include that final certificate of divorce with the application package. But normally you're not doing an open work permit with a
Yeah.
spousal sponsorship. So that's probably a situation where somebody's here, maybe they're working as a skilled worker and they're under the temporary foreign worker program or one of the international mobility programs and they're trying to bring a spouse. Or maybe they're a student and they're looking for an open work permit for their spouse. So it sounds like it's a little bit of a different situation, but if there's any question about are you legally married to that person, then it helps to put that prior divorce certificate and then the new marriage certificate showing that you were married after the date of divorce, of course.
Yeah. And Yasmin, I'll ring the bell, which means you should really book a consult. We can sort through this. It's possible, I guess, Alicia, that Yasmin is filing an in Canada spousal sponsorship application and including an open work permit application with that. And then obviously in those circumstances, yes, divorce certificates are required because you're submitting the work permit application together. It's a joint application generally. But as you can see, you guys, we spend a lot of time speculating about all the possible permutations. And, these are absolutely to be considered as general immigration information and not legal advice. And if you do require specific legal advice, please don't hesitate to reach out to us. We would be happy to work with you and to help you navigate what on the surface appears pretty simple, but in reality can be pretty darn complex. All right. So remember, in the link below, Alicia has the blog post that she's drafted, and that's found on our firm website. I also want to point something else out here, and I'll flip over here and show you the Canadian Immigration Institute. When you click on CR courses right here, you'll see that we have the TR to PR pathway, which is still open because there are the healthcare workers, essential workers. There's still room for people to apply under that program. Our express entry course, which I'm really excited about, is back after just about a 3-month layoff. And that masterclass I'll be hosting starting this Monday coming up. So the cart is just about closed for that. I'm not sure when I'm going to open it up again, but this is where you have an opportunity to join me every single evening, every night next week to get your questions answered about express entry, as well as access for life to all of those live sessions that we do with just the people who subscribe to this group, as well as there's over 50 individual video lessons and tutorials to guide you through the whole express entry course, full of tips, strategies, checklists, sample documents, the works. So that's all available to you for life. And then the bonus is a masterclass with me, 5 sessions every evening at 5 p.m. Mountain Time, all throughout next week. And there's it's all housed in a private Facebook group where you can post your questions if you're not able to make a live, and everybody's questions get answered. So that's the express entry. But given the topic that we have today, we are also getting ready to launch our spousal sponsorship course. So make sure that you go here, click on the get notified when the course goes live, and it will then prompt you to provide your name, email, and a phone number so that we can reach out to you the moment the course is ready. And I guess one thing I'll point out, Alicia, the reason that the course is not launched yet is because of the government releasing their new online process. So we're waiting for the dust to settle there a little bit because we don't want to put a whole bunch of time into creating a paper-based course when the government's they're migrating to a more fulsome online application, which I think we're all anxious to see happen in any event. All right.
Absolutely.
Okay. Well, thank you so much, Alicia, for joining me this evening. And make sure that like I said, if you have any questions, don't hesitate to reach out, book a consultation with Alicia or myself. or Susan, depending on what your schedules are like and the availability for appointments. All right. Take care, everybody. We will see you soon.